Okay, I am doing my case on the Terry versus Ohio. And the Terry versus Ohio case of 1968 was a decision by the United States Supreme Court which held that the Fourth Amendment prohibited an unreasonable searches and seizures, and it's not violated when a police officer stops a suspect on the street and frisks him or her without probable cause to arrest. If the police officer has a reasonable suspicion that the person is committing or is going to commit a crime and has a reasonable belief that the person may be armed and presently dangerous for their own protection, after a person has been stopped, police may perform a quick surface search of the person's outer clothing for weapons if they have reasonable suspicion that the person stopped is armed. The reasonable suspicion must be based on specific facts and not merely upon an officer's hunch. On October 31st of 1963, while on a downtown beat which he had been patrolling for many years, Cleveland Police Department Detective Martin McFadden saw two men, John W. Terry and Richard Chilton, standing on a street corner at 1276 Euclid Avenue and acting in a way the officer thought was suspicious. Detective McFadden observed the two proceed alternately back and forth along an identical route, pausing to stare in the same store window. Each completion of the route was followed by talking between the two on the corner. The two men repeated this alternately between 5 and 6 times apiece, in all, roughly about a dozen times. After one of these trips, they were joined by a third man, who was Katz, who left swiftly after a brief conversation. Suspecting the two men of casing a job or a stick-up, Detective McFadden followed them and saw them rejoin the third man a couple blocks away in front of a store. The officer approached the three, identified himself as a police officer, and asked their names. The men mumbled something underneath their breath, whereupon McFadden spun Terry around, patted down his outside clothing, and felt the pistol in his overcoat pocket. He reached inside the overcoat pocket but was unable to remove the gun. The officer ordered the three into the store. He removed Terry's overcoat, took out a revolver, and ordered the three to face the wall with their hands raised. He patted down the outer clothing of Chilton and Katz and seized the revolver from Chilton's outside overcoat pocket. He did not put his hands under the outer garments of Katz or under Terry or Chilton's outer garments until he felt the guns. The three were taken to the police station. Terry and Chilton were subsequently charged with carrying concealed weapons. The defense of the charged individuals moved to suppress the use of the seized weapons as evidence on ground that the search and subsequent seizure were a violation of the Fourth Amendment to the United States Constitution. Though the trial court rejected the prosecution theory that the guns had been seized during a search incident to a lawful arrest, the court denied the motion to suppress the admitted weapons into evidence on the ground that the officer had cause to believe that Terry and Chilton were acting suspiciously and that their interrogation was warranted, and that the officer, for his own protection, had the right to pat down the outer clothing, having reasonable cause to believe that they might be armed. The trial court made a distinction between an investigatory stop and an arrest, and between a frisk of the outer clothing for weapons and a full-blown search for evidence of a crime. Terry and Chilton were found guilty, and Intermediate Appellate Court affirmed the conviction, and the Ohio State Supreme Court dismissed the appeal on the ground that no substantial constitutional question was involved. So that being said, that being the case, I believe that the case was right and that the police officer did have the right and reasonable suspicion to go up and search them, and they were acting suspiciously, and he watched them for a while and saw what they were doing. So I believe everything he did right, and that they were rightfully found guilty because they were rightly found guilty because he followed the procedure and he waited until he felt them on the outside of the clothing. So he didn't go into their clothing, he felt it on the outside, which is legal. So I felt like the police officers were in the right and that it was a good case, it was successful.